us more from our senior judicial analyst, Judge Andrew Napolitano, on exactly what we're hearing regarding Fast and Furious.
Well, remember the House held him in contempt, and
Sure.
that's just a vote by the House of Representatives. That has no teeth to it. The only teeth will come when a judge orders him to do something. So basically, the House of Representatives filed a lawsuit today in which it asks a judge to invalidate the president's invocation of executive privilege, have Eric Holder turn over the documents to the court, have the court look at the documents in private, and then the court decide which documents should be revealed and which documents should be retained. That is not something the Justice Department wants done, and it's going to take a long time. This is not something the House is going to get done even during the tenure of this House. It'll be another House of Representatives, the one that is elected this fall, in whose hands this will fall for a resolution.
You say it's a certainty that they will at least look at this.
Yes, a judge may very well dismiss this complaint, in which case the House is back to zero. Or a judge may not dismiss the complaint, in which case he or she better open up a large facility for all the documents to be shipped to for he or her to start looking at.
A large facility?
Well, like a couple of jury rooms, because, well, you're talking about 25 to 40,000 pages of documents as to which the president claimed executive privilege. First, the judge has to decide if executive privilege applies. If it does, then he doesn't look at anything. If it doesn't apply, then he starts looking at each document individually and deciding which one goes to the House and which one goes back to the Justice Department. The last time this happened was when the special prosecutor sued President Nixon, and John Sirica started looking at documents in secret.
Yep.
And we know how that ended.
Yes, we've seen that movie.
Yes.
Sir, it's good of you. Thank you.
Pleasure, Shep.
Have you and your attorneys produced internally the materials responsive to the subpoenas?
We believe that we have responded to the subpoena.
No, Mr. Attorney General, you're not a good witness. A good witness answers the question asked. So let's go back again.
Yikes. After countless congressional hearings, Attorney General Eric Holder still won't hand over the documents requested related to the Fast and Furious gun-running scandal.
Now, because of a new lawsuit filed against Holder, a federal judge is to step in. Joining me now, and joining us now, is Judge Andrew Napolitano, Fox News senior judicial analyst.
Good morning, guys.
Good morning.
Good morning.
We were talking about the complaint, a long complaint.
Right.
You've studied it.
Right.
What does it say, and will they win in the end? Speculation, obviously.
Yeah, I mean,
what's going to happen
I
here?
could speculate if I knew who the judge was.
Right.
But what they have asked...
Judge is a Democrat.
Oh, I didn't even know it was
Okay,
a sign.
it's a Democrat.
Okay. What they have asked the court to do is to invalidate the president's invocation of executive privilege. This has happened before. This happened to President George W. Bush after he left office. Once that's invalidated, assuming the court does it, then they have asked the court itself, to review all these documents. You're talking about 75 or 80,000 pages. It's going to take the court a long time to do that.
Wow.
And decide which one stays in the Justice Department custody and which one goes to the Congress. If the judge does that, that will effectively negate Eric Holder's wishes to keep the documents to himself.
And this was done by Congress because the U.S. attorney in Washington failed to act on the criminal contempt that Congress had passed, correct?
You know, it's funny because Peter's correct. The complaint indicates that the House of Representatives asked the United States Attorney for the District of Columbia, who works for Attorney General Holder, to prosecute him, and he said no. The complaint also indicates that if Governor Romney is elected president and a different U.S. attorney is in Washington, D.C., they might, and the Republicans still control the Congress, so 3 Fs, they will ask that U.S. attorney to prosecute Eric Holder, who, of course, will no longer be the Attorney General and will no longer have custody of the documents.
Well, one person who desperately wants to get to the bottom of this is Congressman Darrell Issa from California, and he was on Greta last night trying to see who lied.
They lied to Congress. They then covered it up for 10 months, and that's what they're claiming privilege. Much of what we're asking for is who lied to us, who produced the document behind the scenes, did they know or didn't they know they were providing it? That's a very simple standard.
Here's what he's saying, and I think he's got a very good point. He's saying that they offered, the Justice Department offered documents to Congress in the course of negotiation, and then suddenly the president said those very documents were subject to executive privilege. The Justice Department can't have it both ways. and they're going to ask a judge.
It was 8
to
months
resolve
later after the documents were initially asked for,
Yes,
right?
yes.
So on the last day, say, "Oh no, executive privilege applies."
The other issue is this will never be resolved before election
I was just
day.
going to say, I mean,
No,
what are
even
the
if
chances?
even if that judge spent 5 hours a day reviewing those documents, he wouldn't be finished by election day, and no judge is going to stop just to look at those documents.
As we go out the door, executive privilege. No state secrets involved here. That
No.
usually involves state secrets
Correct.
or the president being involved, and neither seems to be part of the facts.
You're exactly right. Executive privilege applies to military, diplomatic, or sensitive national security secrets that are intended to inform the president himself. Could that be why Eric Holder is so tenaciously holding on to these documents? What did the president know, and when did he know it? We won't know that until after Election Day,
All right.
if ever.
And just so the blogs don't go on fire, you and I were both in Vienna and Prague, but not together.
Correct.
Why not?
We missed each other by a week.
It's such a bummer.
Could have had a great dinner, some
We could have had
strudel.
espresso together.
Strudel,
Yes. Espresso's everywhere.
I know. All right, Judge. We'll see you soon. Thanks
Thank
so
you,
much.
guys.
Well, now to what's new in the Operation Fast and Furious investigation. It's been a month and a half since the House voted to hold Attorney General Eric Holder in contempt of Congress. And still, he hasn't turned over certain documents that House Oversight Committee would like to see. Now the committee is suing Holder and asking that a federal judge invalidate the president's assertion of executive privilege.
Executive privilege was simply a tactic in the final hours as we were voting contempt. There was never any question that that they're trying to create this new deliberative privilege. But let's understand something, Greta, and I think this is the important thing we all understand. They lied to Congress. They then covered it up for 10 months, and that's what they're claiming privilege.
That's Congressman Issa on the record. Judge Andrew Napolitano is a Fox News senior judicial analyst. So, Judge, does this come down to just one judge's decision?
Well, it will come down to one judge's decision, and then whichever side loses will appeal it, and it'll go to a panel of 3, and then they'll appeal it to the Supreme Court. Basically, once the House held Eric Holder in contempt, it sent him the contempt citation and said, cough up the documents. He refused. It then went to the federal prosecutor, the U.S. Attorney for the District of Columbia, and said, indict him for criminal contempt. And he refused to be indicting his boss. So its only alternative now is to bring a federal district court judge in. So they filed this lawsuit against Eric Holder as the Attorney General of the United States. And in the lawsuit, they ask a federal judge to invalidate the invocation of executive privilege and to look at the documents himself in private and decide which ones the House is entitled to receive and which ones should be kept confidential.
You mentioned you expect this to go as high as the Supreme Court. So I'd like to, in the context of that, ask you a little bit about the timeline. When does this first judge have to make a ruling on this?
After Election Day, and that's probably what's most key here because that'll remove the politics from it. However, the complaint intimates that if Governor Romney is elected president, the House of Representatives, if it still stays in control of the Republicans, will go to the new U.S. Attorney for the District of Columbia, the one that a President Romney would appoint, and they will ask that person to seek the indictment of Eric Holder. Of course, at that point, Eric Holder will no longer be the Attorney General.
So it's not specific to the individual. It's specific to the Office of Attorney General to hand over these documents.
Yes. Meaning these documents could fall into the hands of a Republican Attorney General in 6 months, who would presumably share them with Republicans in the House of Representatives.
Why does it take so long? Why is it going to take a couple months? Why are we going to wait?
One of the reasons it will take so long is this case has to get online with other cases assigned to the same judge. But Jenna, the real reason it will take so long is there are 75,000 documents, many of which are more than 1 page, and a federal district judge will have to sit in a windowless room and look at each one of them.
Oh, come on. Judges aren't that busy, right, Judge?
Not an enviable task.
You got a lot of free time on your hands. It's not like you're ruling on anything important. All right, Judge, thank you so much. We'll
Always a
continue to
pleasure.
follow this case, as always, bit by bit and step by step.
A lawyer for that self-proclaimed neighborhood watch captain who shot and killed an unarmed teenager in Central Florida says his team has decided not to rely on the so-called stand your ground defense. That's the law in the state of Florida, and others for that matter, that allows a person to use deadly force in self-defense rather than run away. The lawyer now claims it doesn't apply because he says George Zimmerman had no opportunity to back down from this confrontation. Remember, according to George Zimmerman, 17-year-old Trayvon Martin attacked him, punched him, and slammed his head into the pavement. But prosecutors charged George Zimmerman with second-degree murder, claiming he profiled the teen, then followed him. They point to 911 calls leading up to the shooting, calls during which Zimmerman reports seeing a, quote, real suspicious guy who looked up to no good. Meantime, a 3-judge panel set to decide whether George Zimmerman should get a new judge. Defense lawyers claim the current judge is biased against their client, and this week appealed his decision that denied their request to disqualify himself. With us now, our senior judicial analyst, Judge Andrew Napolitano. So let's start with stand your ground. Megan talked about this a little bit in the last hour. No stand your ground defense to be relied upon here.
Right. Stand your ground defense requires a hearing before the judge at which Mr. Zimmerman would have to testify and at which the prosecutors could cross-examine him, and the judge would decide whether or not stand your ground applies. The defendants distrust this judge because of strong critical statements he's made about Mr. Zimmerman, particularly about Mr. Zimmerman's credibility. Those statements may be well-grounded or they may not be well-grounded, but they indicate to his lawyers that they would not likely prevail in such a hearing and they would run the risk of showing all their cards, so to speak, to the prosecutors when they cross-examined him. So instead they're going for regular, standard, simple self-defense. Everybody understands what self-defense is. It's not some technical new law, controversial law enacted by the legislature. B, it will be decided by a jury. C, there will be no showing of your cards ahead of time to the government. So that, I think, is why his lawyer made that decision not to do the stand your ground defense, but to do simple self-defense at trial. While that's going on, they're trying to get a new judge.
And how difficult is that?
It's very difficult, but it shouldn't be. And I will tell you this. When a judge, from personal experience, when a judge dislikes a defendant, whether the dislike is well-grounded or not, the judge should get off the case. Because that defendant, whose liberty is at jeopardy for 20 years, is entitled to a judge who is absolutely neutral. If something happens in the courtroom that causes you strongly to dislike one of the parties and the jury trial hasn't started yet, you should get off the case. That's the general rule of thumb everywhere in the country. This judge decided not to get off the case. That's why it's being appealed to an appellate court, which will rule soon.
Specifically, well, there were some gratuitous accounts, according to the defense, but specifically, this was about when the defendant said that he didn't have much money, and then the judge later found out that he did, and the judge was visibly angry.
Okay, now here's the flip side of the argument. When you lie to a judge, to the judge's face, I mean, that is enough to get anybody angry at you.
Yeah.
Jurors get angry at that. Judges get angry at that. Some judges' anger can dissipate. I was mad at you 3 weeks ago because you lied to me with respect to the bail hearing. I'm not mad now. We remedied it. It's ancient history. That's the argument that the prosecutor will make in behalf of this judge. Now, he does seem to be government-oriented, so the prosecutors really want to keep him. That's a function of personality and history, and it's the luck of the draw. That's why we have jury trials.
All right, we'll see how this plays. Judge, thank you.
Pleasure, Shep.
A Fox News alert. A Pennsylvania judge has just refused to block a tough new voter ID law from going into effect in the state of Pennsylvania. Now, several states, as you know, with similar laws already involved in lawsuits with the federal government. Civil rights groups are claiming the law discriminates against minority and elderly voters, while Republicans say this is going to cut down on voter fraud. Now, Judge Andrew Napolitano is a Fox News senior judicial analyst. It's great to have you, as always.
Good to be with you,
70-page decision. It's online. I've read parts of it. Here's what I found. First and foremost, the judge says, you know what? In this day and age, how is it really an undue burden to have an identification?
Well, one of the reasons that this federal judge said that is because that's basically what the Supreme Court said when it upheld Indiana's law, which is now Indiana's voter ID law, Greg, which, as you know, and a lot of people watching us probably know, has pretty much become the standard for state voter ID laws because the legislatures that enact it know that a similar law has already been upheld. So basically, the federal judge in Pennsylvania, and I've not seen it, but from the summaries of it that I've seen, has indicated this is not that far from what the Supreme Court upheld in Pennsylvania. There is a problem with in Indiana. There is a problem with voter fraud in this country. Voting is essentially managed by the states, not by the federal government. And some states, Indiana and Pennsylvania, have decided to address this, and they've addressed it in a constitutional way.
And the judge also points out, look, if you don't have identification, you can always vote by provisional ballot or absentee, and that's later verified that you are the person you purport to be.
Correct. A provisional ballot is one that is only counted if it would affect the outcome.
Right.
So the provisional ballots, we know this for going back to Florida in 2000. The provisional ballots are put aside. If the election is within 0.5%, then they start counting them.
The other thing the judge pointed out is, look, you have, lawyers, presented me with evidence, hard evidence, of voter fraud, that it is a problem. And therefore, I find this to be a rational basis for the law.
You know, this is very interesting, Greg. And as a lawyer, I know you know this, and maybe a lot of the folks watching us don't. But laws are presumed to be constitutional. And so it is the burden of the challenger to prove that it is unconstitutional. Not so with the regulation of voting. With the regulation of voting, the state must prove that its regulation is consistent with the federal requirements, that there is a real need to address voter fraud. And the state of Pennsylvania, the lawyers for the state of Pennsylvania were able to do that here.
One of the arguments for those that on the Democratic side who challenge these voter ID laws is, look, what you're doing is you're really discriminating against minorities and other individuals from participating in elections, and yet the evidence would seem to indicate otherwise. In Indiana and other states, minority participation is actually up.
Yes, it actually is up, because most people discover it's not that difficult to prove who you are, whether you use a government-issued ID or something akin to it. It's not that difficult to get it. You don't have to have a driver's license. You don't have to have a car. The government will get you the ID.
A similar case in Ohio regarding voting. Ohio has cut 3 days out of the early voting process for everybody except for members of the military and those Ohioans who live abroad.
Right.
Obama campaign has filed suit saying, wait a minute, you can't do that. It goes to court today. What's the burden on the Obama campaign?
The Obama campaign must show that it is more likely than not that the outcome of the enforcement of this statute will result in a class of people, usually minorities, not being able to vote. That is a very, very difficult burden to show. On top of that, we now have these series of federal cases, the most recent of which we just finished talking about in Pennsylvania, in which federal courts are deferring to the decision of state legislatures, as long as they're within the boundaries of fairness, when it comes to managing elections.
So,
I think the Obama campaign has made a political mistake by suing, and a legal mistake by suing as well. I think
political mistake in what respect?
I think there'll be a reaction to it.
Backlash among voters. What are you trying to do here?
Yes, exactly.
Especially members of the military.
Precisely. This was intended to help the military. Those good folks are going to say, you know what? They don't want my vote.
Judge Andrew Napolitano, breaking news on 2 stories. Thank you so much for being with us.
Pleasure, Greg.
All right.
Well, before the bankruptcy, the warning. A new report showing just 10 days before Solyndra went belly up, the Department of Energy official in charge of those green loans emailed this out to colleagues, and I quote, "Don't ever send an email on DOE email with personal email addresses. That makes them subpoenable." Okay, Judge? Good legal advice, bad legal advice, or illegal advice?
It's uninformed advice. In a criminal or congressional or even administrative investigation, say regulators are investigating you, he has to answer to a inspector general. He also has to answer to a congressional committee. He may also have to answer to federal prosecutors. They can get everything. They can get the email of a Department of Energy official using his own personal BlackBerry in his Department of Energy office to email another Department of Energy person on his personal BlackBerry using non-government email addresses.
What about that email itself?
Well, that email is sort of saying, use your personal email because government emails are subpoenable. Even personal emails are subpoenable for a congressional, administrative, or criminal regulation. Look, I don't know what was in this guy's head. He obviously knew that this thing was going to go south. Maybe he was saying, be careful what you say. That's not a crime. Maybe he was saying, if you have to say something sensitive, don't say it in a government email because they'll get government emails. That's wrong because they'll also get personal emails. I didn't see any deception in there. I didn't see him say lie. I didn't see him say destroy.
But it had me thinking, you're the lawyer, but as you know, I watch a lot of legal shows. So,
you do.
As you know, I'm an expert. So, but do you think that you can look at this and say, well, he must be sending out that for a reason?
Well, I think he probably knew what was going to happen. I mean, this was 10 days before Solyndra went south.
So he's pre-hiding something.
They had to know. You know,
That's a leap, I know. But.
it is a leap, but I'll tell you this much. He is someone that I would want to interrogate if I worked for the Justice Department or if I were a lawyer for a House or Senate committee investigating the collapse of Solyndra. And I would say, what did you learn right before you sent that email? And what was in your mind when you sent that email? And when did you know that Solyndra was going to go south?
I'd
And
hate to be on the other side of you,
did you
haranguing
start tailoring your language,
Wow.
knowing the emails were going to be subpoenaed after you learned Solyndra was collapsing?
From what you're saying, it's not bad to say, don't send emails.
It is not bad to say don't send emails. It is bad to say delete them. It is bad to say destroy them. But it is not bad to say don't send them.
But you said if they're sending stuff back and forth via personal email, authorities can retrieve those.
Correct. He apparently didn't realize that, because he's basically saying, if you have to communicate to me, use your and my, I'll just make it up, Gmail.
Right.
Don't use the US.gov or .gov. That wouldn't insulate them from a subpoena at all. The government can still get those.
Do you think this whole Solyndra thing and what people knew and when they knew it is bigger than we think, still bigger than we think?
Yes, I do. In my own view, it represents a reprehensible attitude on the part of government, that they can pick winners and losers, that they can waste money, that they can continue to waste money when they know the winners that they've chosen have already become losers. And that attitude has no place in a free society. That's our money they're playing with. It's either our tax dollars or it's money they borrowed in our name that they're going to have to pay back.
Judge, thank you as always.
Pleasure.